From Silkwood to Snowden, whistleblowers have garnered both accolades and harsh criticism for exposing illegal practices in the workplace. But should all employees be protected under our whistleblower laws, and should we even care that they're protected? I'm MaryLynn Schiavi, and welcome to Pro Se Nation. Joining us for this edition of Pro Se Nation is Andy Dwyer, an attorney and member of the Dwyer Law Firm in Newark, New Jersey, specializing in employment discrimination and civil rights. His practice is focused exclusively on litigation representing employees bringing claims of discrimination, harassment, and retaliation against their employers. Also joining us is Marcus Rayner, president and founding member of the New Jersey Civil Justice Institute, established in 2007 as a business organization dedicated to civil justice reform and the promotion of sound legal policy. Okay, since this program is for the average person, we're going to try to define our terms before we really launch into our discussion. So what is the difference between a whiny and complaining employee and a whistleblower? Well, Andy, would you like to take that?
Possibly there is no difference. George Bernard Shaw once said that the reasonable person adapts himself to the world around him, and the unreasonable person insists that the world adapt to him. Hence, all change depends on the unreasonable person. So a lot of whistleblowers are difficult people. They are sometimes unreasonable. It doesn't mean, though, that what they are doing is wrong, and it doesn't mean that they should be punished for it. I think one of the things that's important for non-lawyers to understand is that there are actually very few whistleblower cases that are ever brought. There are a very, very tiny number of cases that are brought, but the statutes nonetheless have an effect on all of us, because if somebody feels comfortable in the workplace to complain about something, to publicly disclose something about a threat to the environment or our financial system or public health and safety, that is a benefit to all people, even people who never blow the whistle in the course of their jobs at all.
Marcus, would you like to weigh in on that?
Well, I think it's instructive in this case to look at the statute itself. And when you look at the statute, the words you see most often are fraud, defraud, criminal, misrepresent. And so I think the statute was intended originally to have whistleblowers blow the whistle on things that were actually legally unsound, fraudulent misrepresentations of products. Yes, there is room there for other broader areas, but I think the statute's pretty clear that what they're going for is the most severe instances where an employee knows an employer is doing something actually illegal, defraud, or fraudulent.
The statute, though, doesn't actually say that, just so you understand. The statute applies to things that are illegal.
Now, we are
criminal.
talking about the
I apologize. We're talking about the New Jersey Conscientious Employee Protection Act, popularly known as CEPA, which is one of the broadest whistleblower statutes in the country. Unlike, say, discrimination, where there's a federal statute that applies everywhere in the country that bars discrimination, there's no such thing as a generic federal whistleblower law. So there are whistleblower laws like Sarbanes-Oxley that apply to publicly traded companies when there's concern about deceiving investors, or there are whistleblower laws where somebody supposedly is defrauding the U.S. government, the so-called qui tam statute. But there's no generic whistleblower statute for any kind of complaints. New Jersey is one state that has a statute like that, and it's very broadly written. In addition to things that are illegal, not just criminally illegal, but also civilly illegal, it also prohibits, as Marcus said, things that are fraudulent, but it also prohibits anything that is a violation of a clear mandate of public policy. So that is a much broader statute than you're going to find in most states. And the scope of, and that's right in the language of the statute. I didn't invent that. That's in the language of the statute. So the legislature obviously intended to draft a very broad statute, and it did so.
So the two of you, you have very different perspectives on a case that was just handled, actually just settled by the New Jersey Supreme Court on July 15th, 2015, and that was Lippman versus Ethicon. Andy, can you tell us just a little bit about the basic facts of the case and the cause of action, what brought it to the Supreme Court?
So Joel Lippman was the chief medical officer of Ethicon, which is a J&J subsidiary. And during the course of his employment, he often raised complaints, or he alleges this. The case has never been to trial yet. He alleges that he raised complaints about various products and devices that were made, or medicines that were made by Ethicon, that he believed violated statutes, including the FDCA, and also threatened public health. And so his allegation was that after a series of complaints along those lines, he was ultimately terminated. Ethicon, of course, has a different position. Their position is, yes, he raised issues about certain products and devices. We didn't have a problem with that. We actually supported him in that, and his termination actually had nothing to do with that. His termination had to do with the fact that he was allegedly involved in an inappropriate relationship with a subordinate. Which side is right about that, I have no idea. This, like I said, I've never been to trial. The issue in the case that got the Supreme Court of New Jersey interested was that the lower courts dismissed the case without ever having a trial on the grounds that because he was the chief medical officer, it was his normal job duty to raise these kinds of concerns, and that you should not give protection to somebody who is raising concerns in the course of his or her normal job duties. So, for example, a plant safety inspector raises concerns about plant safety all day long, and you shouldn't give protection for that person when they complain about something that violates the law. The Supreme Court of New Jersey said, well, that's not what the statute says. The statute simply identifies various categories of whistleblowing, and it doesn't matter what your job functions are. If you engage in whistleblowing, you can't be retaliated for doing it.
Right. So Marcus, now your organization had a very different perspective on this.
Well, our concern is, and therein is the problem, our concern is that you potentially create a class of employees whose job it is to raise concerns inside the workplace. And even if you comply with those concerns, you're now open to an untouchable class of employees. So, for example, in Dr. Lippman's case, again, this hasn't gone to trial, so we'll see what the ultimate fact-finding is. But Ethicon concedes, and he readily concedes, that in many of his concerns, many of the concerns he raised were addressed by the company. In fact, the penultimate concern he raised right before his termination was to remove a product from the marketplace that he thought was unsafe, and Ethicon did so. And then they terminated him for another instance, which was sexual relationship in the workplace that they found inappropriate with an employee who reported somehow directly to him or indirectly to him. So if it's in fact the case—
That was alleged.
Alleged, correct.
Yes. Okay.
If it's in fact the case that employees who raise those concerns and never go outside the company or never formally raise those concerns to a superior can file CEPA claims upon any kind of adverse employment action, the legislature may have potentially created a class of employee that is untouchable. And the problem for large pharmaceutical and technical device manufacturing companies is that no drug is uniformly effective and no drug is uniformly bad. And these companies have to weigh the risk of bringing a product to market with the potential payoff for the patients, for the potential profit for the company, and they have to have people inside the company who can freely and openly discuss that. And if that discussion is a protected discussion, it's a little bit of a public policy problem for some of these employers.
So there's a couple of things that I think should allay the concerns of Marcus and his clients. One thing is, can there be meritless lawsuits brought under the whistleblower statute? Yes. There could also be meritless lawsuits brought under anti-discrimination laws, but nobody believes that, for example, women are untouchable simply because it's illegal to fire somebody because of their gender. There are plenty of women who get fired every day. There are plenty of black people who get fired every day. There are plenty of Jews who get fired every day, even though it would be illegal to fire them because they're women, because they're black, because they're Jewish. So none of those people are untouchable. Nobody thinks that. And we've had an anti-discrimination statute in New Jersey for 70 years. So, if that created an untouchable class of employees, I think we would have noticed by now. This statute goes back to 1986, signed into law by Governor Tom Kean, a Republican, hardly, a left-wing power grab. And there's a couple of reasons why the concerns that Marcus has, I think, are overblown. One is there's very few CEPA cases brought. If you look at the number of workers in the state of New Jersey, the likelihood that one of them will bring a claim under CEPA based on court statistics of how many cases are brought is something considerably less than 1/2 of 1/10 of 1%. So, you know, I've got a greater chance of getting struck by lightning on the way home than having one of my employees bring a CEPA claim. The second thing is, if somebody...
And why do you think that is? Now, has it gone down over the past few years? Do you think it's related to the economy, people being nervous about their jobs?
I don't believe so. The court statistics break it down to different categories of cases, and frankly, the CEPA cases are so few in number that they don't even get their own category. So when I say it's something less than 1/2 of 1/10 of 1%, that's because all of the cases that CEPA goes with, like discrimination cases, defamation cases, all that is less than 1/2 of 1/10 of 1%, because CEPA is so infrequent. I don't think it's gone down. I think it's just an uncommon thing. People do not want to get fired,
right,
and they don't want to lose their jobs. And you know, whenever I have a client who's still got their job, I always say, listen, you're better off having a job than you are having a lawsuit.
Right.
You know,
right.
so you got to do what you have to do to hang on to your job. You got
right.
a mortgage to pay, you got children to take care of.
But the thing is, we want employees, I mean, let's face it, they are the first line, often, you know, the Ford Pinto case, and certainly one could even look at the economic downturn that we just barely survived. Certainly many people along the way knew that there were predatory lending practices that really, you know, could have circumvented the Great Recession that we had, right?
If I may,
Sure.
Yes, we want a strong CEPA statute. Nobody's arguing differently than that. I would actually make a distinction in this case. Andy's right, you can't fire a woman because she's a woman, or a minority because they're a minority. Right. I'm arguing you should be able to fire a risk manager for doing a bad job. That it is actually a part of the core job function that if they're not properly weighing the risk-reward analysis for the company, they should be able to be terminated and not be protected by CEPA. That's the public policy difference, I would argue.
But the statute provides that. And in fact, the New Jersey Supreme Court has explicitly said that if somebody is fired for making complaints,
right.
that are baseless complaints, that's okay. So it's not the case that if you complain about anything and everything in the world, you're protected. Your complaint has to, first of all, identify something that, if it really was occurring, would actually be a violation of law or claim to mandate a public policy.
Okay.
That's number one.
That's right.
So you can't complain that, you know, you just don't like the sandwich in the cafeteria.
Right.
And number two, you have to have a reasonable good faith basis for believing that it's actually occurring.
Okay.
So you can't just make up wild things. And the Supreme Court has specifically said that if employees are making baseless complaints, the employer has every right in the world to fire them for the complaints.
Right.
I think the thing about the plant safety inspector, the so-called untouchable employees, the thing that's important to remember is that if that plant safety inspector brings a CEPA claim, they've been working there 10 years, they've been doing their job every day, day after day after day for 10 years, they've got to explain to the court, what is it that all of a sudden, after 10 years, the company decided to fire them?
Right.
You know, that's a big causation problem. And likewise, if there's multiple plant safety inspectors, if there's multiple people complaining about these things, why weren't all these other people fired? So there are causation problems for people who are in those positions. I don't think they have a slam dunk that they get to file their case and go to trial in every case. Are there frivolous cases brought? There are. But that doesn't mean you repeal the statute.
And the Lippman case is instructive, and ultimately the trial court will decide whether Ethicon was right or Lippman was right. It's worth noting he brought a discrimination case alongside this at the beginning, which was summarily dismissed, so voluntarily dismissed. So he was throwing a little bit of noodles on the wall to see what would stick potentially. We'll see what the trial court says. But yes, you know, employers sometimes retaliate, and yes, frivolous cases get brought. The point is, I'm arguing the statute ought to clarify and separate the wheat from the chaff here. And what you want is, in the Lippman case, he was fired after many years for allegedly a sexually inappropriate relationship in the workplace, and he filed a CEPA claim. Ethicon's point of view is it wasn't about the CEPA claim, and we should be able, and they will defend that, but what we need to do is have a CEPA statute that recognizes that there are certain jobs which should be evaluated based on their ability to weigh these risks and rewards.
So here's, of course, the problem, which is, imagine the situation like Dr. Lippman's, and I'm not saying this occurred, but imagine that's the situation. They say, well, he's been complaining about this stuff for years, we never fired him before, we believe he had this inappropriate relationship with his subordinate, that's why we fired him. He's just pulling the latest complaint as a basis to say that he was fired. Fine. But then it turns out that in pretrial discovery, you find a memo from his boss that says, I'm so sick and tired of this guy complaining all the time.
Right.
This last complaint was the straw that broke the camel's back. We're going to have to pull this product off of market. You know how much money we're going to lose? Fire this guy and come up with any reason for doing
Right,
so.
right.
I'm sure that Marcus would agree with me that that ought to be illegal. And so it's a factual question in any case. You can't just look at the guy's job duties or his job description and say, well, you don't get protection, no matter what you did and no matter what they did.
I first want, and I also want to clarify, you wrote an amicus brief, and for those who don't know what an amicus brief is, that's a friend of the court. Can you explain what that means? And also, my question, since this is called Pro Se Nation, can a pro se write an amicus brief?
Sure.
Okay.
Amicus briefs is just short for a Latin term that is amicus curiae, which means friend of the court, and not just now and not just in New Jersey, but in the English legal system that our country inherited for hundreds of years. It's always been possible for somebody who's not a party to a case to ask for permission to submit an argument to the court because they are interested in the outcome of the case. My clients in this were 27 organizations of labor, environment, consumer organizations that were obviously interested in the outcome of this case, and so they asked for permission to do that. Marcus
And you
did the same
you
thing.
did this under the auspices of NELA, or not?
Our primary client was actually the New Jersey Work Environment Council, which is a coalition of labor and environmental organizations. But NELA, which is the National Employment Lawyers Association, also was one of the 27 groups.
And for your viewers, it's worth noting, I mean, when a case like this gets to the Supreme Court or the Appellate Division, serious questions of public policy are at stake. And so there are a lot of different organizations that want to represent their members' views and explain something to the court that they might not have in front of them from the facts of the case.
Right, right. So, and you started to answer, and a pro se, someone who is
It's
not an attorney.
Not super common.
Okay.
But somebody, if they wanted to just be themselves, I'm Jane Doe, and I care about the outcome of this case, and I would like permission to make an argument to the court, they would be permitted to do so. I don't think it's very common.
Does the court have to accept it?
No, they don't. Didn't have to accept our amicus brief either. You have to ask for permission.
So then
you have to make a motion. Making a motion just means making a request.
Right.
So you have to make a request to the court to be granted permission. In our case,
the court can deny it if it.
Absolutely.
Okay.
In our case, they gave us permission to file a brief and also to make an oral argument. And same for Marcus's organization. They did the same thing.
Now, I read the brief that your organization, or the lawyers representing your side, actually, or your view, developed. And, there is an aspect of it that causes concern. The argument that if companies feel that they're vulnerable now in this area, they may not hire as many people to be monitors. Or at least that's how I understood the argument.
Well,
is that
companies respond to incentives like human beings do. And at the same time that we have regulations coming from Washington and Trenton saying we want a culture of whistleblowing, we want a culture of compliance and holding their feet to the fire, the Supreme Court or the law is saying, well, okay, we want you to hire all of these people to monitor and make sure you're compliant, but if they have that honest discussion and ultimately get terminated potentially for something different, they get CEPA protection. We think the public policy needs to respect that tension, that the companies need to have this open and honest debate. They need to encourage, in this case with Dr. Lippman, he sat on a review panel of multiple people that had a back and forth where some people said, no, I think the product ought to go to market, and he said, no, I don't. And that's a healthy kind of intellectual exchange. And as I mentioned before, according to the court documents, the company more often than not complied with his concerns. So you want to have that debate and you don't want to chill it. And that's where I think the public policy has to try to create that environment, both in the law and so that companies know the predictable nature of the law.
Yeah, I don't see how you create an environment of open and healthy debate if people are worried that if they say the wrong thing, they're going to get fired. I think that's the problem. And I think that's why we need
the fear is,
whistleblowers.
From your perspective, it's almost, this is really tough because it's almost like you're saying, okay, if your job is to monitor the air in the factory. So now that's your job, and now you're not protected by CEPA. You've just, you've taken away the rights from a certain number of employees right from the get-go.
I would use a different example. Something as simple as monitoring the air in a factory is probably mandated by certain OSHA standards.
Right.
What we're talking about in most of these instances is, let's say you're a large pharmaceutical company, and you have to decide whether a drug that could potentially help millions of people should go to market.
Right.
And there are some people in the company who say, yes, it's pending FDA approval. Once it gets FDA approval, we should take it to market. And you have a few doctors who say, yes, but there's the potential for these side effects. The FDA may have said it's okay, and you bring it to market. That's a tension that exists in all of these drugs. As I said earlier, there's no uniformly effective drug, there's no uniformly bad drug, and we have product liability disputes over side effects and things that can happen. Companies need to weigh that. They need to weigh that honestly. And if we are too risk averse, drugs that could potentially help people don't get to market. If we're too free of risk, if we're too a non-evaluative, you can bring bad drugs to market. It's not as simple as is the air compliant with OSHA standards or not. These are very complicated, very difficult decisions that these companies make.
Except that if you are merely saying, I'm not sure this is a good idea, let's think about it, that's not whistleblowing. You have to object. You have to say, don't do this. And secondly, it's not enough to say, don't do this because I don't like it. You have to say, don't do this because I can explain to you why this violates the law. And so when you have if the Food and Drug Administration approves a drug, how can you honestly and credibly sit there and say, well, I know the Food and Drug Administration approved it, but I still think it's illegal? That's that is not a reasonable good faith belief. And somebody who files a complaint like that, the complaint's going to get dismissed.
One of the issues that's going to go through in the Lippman case is whether he in fact objected. I mean, the Supreme Court said you can't limit what it means to object, but in a finding of fact, he never went to a supervisor and said, I'm going to raise concerns about this. He never said, absent his objections in the deliberative process, I have higher concerns about this. So if you're the employer, it may have seemed to you that he was just doing his job. And now you come to find out that he had such serious objections that he's filing a CEPA claim. That's where it's difficult from a practical standpoint for the employer to comply with the law and evaluate these situations.
What I'd like to get your perspective on Snowden. Would you like to weigh in on?
Well, I mean that obviously involves a set of different concerns, right? There's concerns about whether he breached national security and violated criminal laws, and I'll be honest with you, I'm not familiar enough with that area of the law or the particular details of his case. I think what's interesting, though, about what he did is it obviously exposed a lot of things for public debate that had not been happening because people, your average American at least, was not aware of the level of collection of data and surveillance. And those are legitimate things to discuss in my opinion, in a free society. You know, I personally don't believe that I should just take the government's word for it whenever they say, don't worry, we're going to do something and it'll be fine. Just trust us.
I'm all for open debate, and if all Snowden had done was prompt a debate, I'd congratulate him. But he stole government property and top secret documents and gave them to a foreign government. That's a crime, pure and simple. I think if he were in the United States, he should be put on trial.
Okay. How many employees, or how common is it for employees to really know their rights when it comes to whistleblowing?
I'm only basing this obviously on people who come to my firm for help. I think most people have only a dim understanding, and I think that for a show like this that focuses on helping people who are lay people, I think an important way in which you could help people who are lay people is understand, you know, again, the goal in life shouldn't be a lawsuit. The goal in life should be to live your life. And so, for example, one of the common mistakes that people make is they complain about something, but they don't really complain. You know, they kind of do it subtly because they're worried about pissing people off. They do it orally rather than writing. Well, if the employer is one that's inclined to retaliate, then that was a bad move, because what the employer is going to be able to say is, you didn't really complain, and where's your proof? So if you're going to complain about something, do it in writing and make it 100% clear that you're complaining. Not, I think you might want to think about this, but I think this is illegal and here's why. If you do that, then you have really engaged, assuming you have a good faith basis for belief, you've really engaged in protected activity. And if you're dealing with an employer that is educated about the law and marginally sane, the employer is going to at least think twice before they decide to target you for something, because they're going to say, their lawyer is going to say to them, well, Bill, I don't know about that. You know, this guy really did engage in protected activity, and it's in an email. So what are we going to do?
Right.
I couldn't agree more. I mean, I think, you know, what businesses need most and want most is predictability, and they know how to respond to a situation where an employee puts them on notice that they think something that's happening is fraudulent or illegal, and the employer will respond accordingly. And if they're an honest employer, they'll be happy to know that information. If they're not, then that's exactly what CEPA was designed to do, was to protect that employee and root out the fraudulent activity. So I agree completely. It's also worth noting, since this is for viewers who may not be familiar with the law, that CEPA requires employers of over 10 employees to post annually the CEPA the rights that employees have. So is that always in the right place? Is that always something employees take the time to read? Obviously not, but employers are required to notify employees of their rights.
A lot of employers are small employers, right?
Right.
I mean, not most employers are the size of Johnson & Johnson. So a lot of employers don't even have any legal advisors, and you know, if they do, it's somebody they have on retainer on a part-time basis. I think that one thing that could be very beneficial from the employer's perspective would be to do the same kind of training that a lot of employers do about on-the-job harassment and discrimination, and train employees and make it clear to employees, you see something you think is you know, fishy around here, tell us.
Right.
It's our company policy that we want to know.
Right.
And in my experience, that's exactly what most employers do. Certainly the large ones, and small ones with small staffs hopefully communicate that message. I mean, the vast majority of employees, like the vast majority of plaintiffs, are trying to do the right thing.
Right.
And they want to comply with the law, and they want to know if there's illegal activity going on in their place of work.
Okay. Well, we are running out of time for our main show, but I would like to ask you a couple of more questions. So if you'd stick around.
Okay, sure.
Thank you for joining me. Thanks for joining us for this segment of Pro Se Nation, which we're calling Whistle While You Work. Thanks so much.